The topic for tonight, one of the trickiest legislative issues for ESDs is annexation. It can affect your ability to work with cities, which is a constant source of strife for some ESDs. Recently, the legislature, in its infinite wisdom, decided to change some of the annexation laws. So a lot is different, and John, being the Chief Legislative Counsel for Safety and our man at the legislature in Austin, has the update on everything those crazy folks did this spring. So without further ado, take it away, John.
Everything's a bit of an overstatement, but we'll try to cover some of the annexation issues and Senate Bill 6 and the impact that Senate Bill 6 is going to have on districts across the state. So without any further ado, let's get started. I want to go through a little bit of the history on annexation. If you recall, in the regular session in 2017, there were a couple of bills put into the mix that would have affected the annexation laws. Both of them, both House Bill 299 and Senate Bill 715, failed to pass. And in fact, Senate Bill 715 by Senator Donna Campbell died in a filibuster at midnight on May the 28th. As a result of that, and several other pieces of annexation legislation that went through, the governor called a special session and added annexation to the agenda. There was one bill that did pass during the regular session related to annexation requirements in the San Antonio area. It extended some requirements that had been put in place for Austin. So if you're in Bexar County or around San Antonio, take a look at Senate Bill 1878. But for the most part, we're going to focus on what the governor added to the special session over the summer for legislation reforming the authority of municipalities to annex territory. That was targeted at House Bill 299 and Senate Bill 715, which failed to pass just by the narrowest of time limits during the regular session. Now, those bills did pass during special session, in particular Senate Bill 6 by Senator Campbell. She worked in conjunction with Representative Huberty and Representative Larson to get that done. Those bills, that bill will become effective December 1st. So just at the end of this week, annexation reform takes place, and it is an extensive rewrite of Texas annexation law. In fact, some of the Texas Municipal League material talks about it being a century that municipalities have operated under the old annexation rules, and that now that this change has occurred, the landscape in Texas is going to be very different for cities. So let's talk generally about annexations and ESDs. Remember that a city can annex into an ESD, and when they do so, they either can leave the area in the ESD or they can remove it from the ESD. There are procedures that apply to the annexation process, and in some circumstances, ESDs are entitled to compensation. Now, when we talk about annexation, there's a lot of laws related to annexation. In general, however, annexed areas have to be in a city's ETJ. Now, the ETJ is the extraterritorial jurisdiction of a city. It allows planning functions of the city outside the city limits. That ETJ boundary varies by population. The smallest cities of 5,000 or less having an ETJ of a half mile, the largest cities having an ETJ of up to 5 miles. Now, the other thing that in general, annexed areas must be contiguous to the existing city limits. There are a couple of exceptions on that, but those are very specific, and I'm not going to get into that tonight. Senate Bill 6, as it was passed during the special session, does not affect all annexations. It only affects certain types of annexations. There are unaffected cities that still go forward with annexation the way they used to, and depending on what kind of city, the laws are very different. So they're home rule cities, they're general law cities. A home rule city basically has the authority that's set out in its city charter and is limited by what the statutes say. A general law city has the authority that's in the statutes and nothing else. Consequently, there are different annexation rules for every circumstance, and if you're in an annexation, if there's an annexation going on in your area, you need to make sure that you're consulting with someone who can tell you exactly what laws are going to apply to that annexation. Now, remember, and this is a big disclaimer, this presentation does not cover all the various procedures for annexations by cities. If you need more details on specific annexations, I've got links to TML's updated guidelines on annexations and to the Local Government Code, Chapter 43, which is where annexation is dealt with in the state statutes. So please turn to those if you need it. So we're going to move and talk a little bit about Senate Bill 6's impact on annexation in general. So Senate Bill 6 requires certain cities to receive voter approval of annexation, either by an election or a petition. Now, it expedites voluntary annexations when cities and landowners agree on services. So if a city can get 100% of the landowners to agree to an annexation and reach an agreement with the city, then they can move forward very quickly. But absent that 100% landowner agreement, they've got to go through an election and a petition process. There are within Senate Bill 6 a breakdown of two different tiers. The tiers really set up what rules apply for which annexations. Tier 1 is a county with a population of less than 500,000 and that's not located or doesn't contain a freshwater fisheries center. Now, the only county in the state that has a freshwater fisheries center operated by the Parks and Wildlife Department is Henderson County. So Henderson County is Tier 2 by definition. In addition, all the Tier 2 counties are kind of defined in reverse. So they're not a Tier 1 county, or they have elected to become a Tier 2 county. So initially in the state, the Tier 2 counties are Henderson, Travis, Tarrant, Harris, Fort Bend, El Paso, Denton, Dallas, Collin, and Bexar counties. All those counties, with the exception of Henderson, have populations over 500,000. Henderson is in by virtue of the definition. There are Tier 1 counties that could opt in through a petition and election process. If a Tier 1 county if the Commissioner's Court receives a petition signed by 10% or more of the registered voters of the county, which is a large hurdle to overcome, it's a very large number, then they would hold an election about choosing to operate under the Tier 2 rules. To date, we don't have any of those. Obviously, the law hadn't gone into effect, and I'll be curious to see if any petition process gets started to try and have that happen, but I wouldn't expect it to be very soon. So, what does Tier 1 and Tier 2 mean? Well, Tier 1 and Tier 2 defines then the municipalities and the rules they have to follow in order to go through the annexation process. A Tier 1 municipality that's wholly located in a Tier 1 county and proposes to annex area that's wholly located in one or more Tier 1 counties. So the only way you get Tier 1 status as a municipality is if you don't touch or affect a Tier 2 county either by where you are currently or where you intend to annex. Tier 2 counties, any city, or Tier 2 municipalities is any city that's partially or wholly located in a Tier 2 county. So where those cities straddle county lines, if they are partially in one of those counties we listed before, they're a Tier 2 municipality. Or if they're in a Tier 1 county and they propose to annex area into a Tier 2 county, they become a Tier 2 municipality and subject to new rules under Senate Bill 6. All right, so what are those rules? These rules really affect Tier 2 municipalities. We'll talk a little bit later about how Tier 1 municipalities operate. It's really generally the same as they used to. But Tier 2 municipalities can annex an area with a population of fewer than 200 people only if the municipality obtains consent through a petition process. Now, that petition has to be signed by more than 50% of the registered voters in the area proposed for annexation. But if those registered voters don't own more than 50% of the land in the area, then the petition also has to be signed by a majority of the landowners. And when we talk about the majority of the landowners, we're talking not about 50% of the landowners, we're talking about the 50% of the owners of land in the area. So they have to own 50% of the land. So it's a two-step process for less than 200 people in an area. You must have both a majority of the registered voters and a majority of the owners of the land by area in order to proceed with annexation. All right, now, for those areas over 200 or more people, this is where the big change came into play. And that requires an election in the area in order for that area to be annexed. So municipality that wants to annex an area that has more than 200 people in population, not voters, population, has to hold an election, and the majority of those voters in that area have to approve the annexation. Now, in addition to that, we go back to that same condition. If those registered voters in the area don't own more than 50% of the land in the area, then the city's got to go ahead and get a petition signed by more than 50% of the owners of the land in the area too. So it's a two-step process. Not only do the voters have to approve it, but a majority of the landowners have to approve it as well. Okay? That's the new impact of Tier 2.
So there's no election if it's under 200 people.
If they're under 200 people, there is no election. The petition process basically replaces the election. I think the intent of the legislature was that if there's fewer than 200 people, we can get all 200 of those people to sign on or not onto an annexation petition. Okay?
Yeah.
So, but if it's more than 200, then we want to go through a full election process to give everybody the opportunity to participate. Now, there are notice and public hearing requirements under Tier 2. So the municipality has to first adopt a resolution saying it's going to go forward and annex an area. That resolution has to have a description of the area and a map. Those have to be detailed enough to allow folks to understand what's being proposed for annexation. In addition, that resolution has to provide a description of the service to be provided and a schedule under which those services are going to be provided. These are designed to educate the voters about what's going to happen once they're annexed so that they can make an educated decision. The municipality has to mail that notice to every resident and property owner in the area no later than the 7th day after they adopt this initial resolution. So the legislature's intent was to put the public on notice and to educate them about what was coming down the road. Now, there's a public hearing that has to be held no earlier than the 21st day and no later than the 30th day after that resolution is adopted. So the timing here is municipality decides to annex. They adopt a resolution. They then send out notice. They're going to have a public hearing. That public hearing will be anywhere from 2 to 3 weeks later. It's fresh in everybody's minds. They can show up and express their opinions. Now, Type 1 or Tier 1 annexations, Tier 1 municipalities, generally, they don't have to follow those requirements that the Tier 2 do. There is a 3-year annexation plan that generally applies. However, there are exemptions to that plan requirements. I'm going to talk about the exemptions first and then talk about what the 3-year annexation plan requires. The exemptions from a 3-year plan are for annexations where there are fewer than 100 residential dwellings in an area. Now, we're talking about dwellings, and so if the city chooses to annex an area with less than 100 residential dwellings, no matter how big it is, no matter how many tracts of land there are, they're exempt from the 3-year annexation plan. Now remember, this is Tier 1 municipalities, so this is the counties with populations of less than 500,000 where these cities are located, and they're not annexing areas in larger counties. Now, the other way they can be exempt from the 3-year annexation plan is if they get a petition from greater than 50% of the landowners within that area. Then they don't have to do the 3-year annexation plan. In either of those cases, and there are some other exceptions, which is why generally we got to look at Chapter 43, but those situations only require a service plan to be adopted by the city, notice to the folks being annexed, and 2 public hearings. Then the city can move forward with its annexation of that area. So, like I said, there's all kinds of scenarios and different fact situations that may apply to either general law or home rule cities, and the local government code in Chapter 43 is where we deal with that. But for those Tier 1 annexations where there are more than 100 or more residential dwellings in the area, they have to follow an annexation plan process. And so like I talked about, fewer than 100 tracts of land, you're not going to have more than 100 dwellings on those tracts. And more than 100 tracts, but less than 100 tracts with dwellings on them, you could be exempt as well. So it all relates to how many tracts there are, how many of those tracts have dwellings on them. A tract with 2 dwellings on it counts as 1 tract for purposes of coming up to your 100 residential dwellings. That's the same requirement that there used to be in the law prior to SB 6. So there's nothing new or different about this in particular. And the process, though, if you have to follow into an annexation plan, just a baseline of education, the process is to annex an area with more than 100 residential dwellings. You first have to add that area to your annexation plan. The city has a formal annexation plan. When they do that, they must notify the landowners, service providers, and railroads out there that they're intending to do this annexation, and they've added it to their plan. They're required to prepare an inventory of services where they solicit from all the service providers information about what services those entities provide. And then they have to send out notice of public hearings. They have to hold 2 public hearings. Then they negotiate with the representatives of the landowners in the area an agreement for how they're going to provide those services. Once they complete all that process, they have to wait until 3 years after the area was added to the annexation plan in order to move forward with annexation. So right now, if we've got cities that are moving forward with 3-year annexation plans and they're Tier 1, they can continue moving with those 3-year annexation plans. If they fell into Tier 2 and they didn't finish their annexation before December 1, they are now having to operate under the Tier 2 procedures. Just because it was already in a 3-year annexation plan didn't give any grandfathering. Okay? Now, there are a couple of things in Senate Bill 6 that applied to multiple entities in both Tier 1 and Tier 2. In particular, there was a provision added that required all municipalities to provide written notice of a proposed annexation to any public entity. There's a definition of public entity in there, but it does include emergency service districts. A municipality that proposes annexation or proposes to enter into a strategic partnership agreement, which is a type of agreement that developers and cities enter into when they create a special district for development purposes. Anytime those type of agreements are proposed, the city has to provide notice to the public entities in that area so that they can have input on the annexation process. That applies whether you are a Tier 1 municipality or a Tier 2 municipality. So everybody in the state now, every city in the state now has to require with that now has to comply with that notice to public entities requirement.
And this was something that we were.
So we were involved in having making sure that notice was provided adequately to everyone. One of the things that we ended up talking to our members about was the fact that sometimes these city annexations would go forward and the ESD would all of a sudden be looking at, oh my gosh, that area is going away. What do? We weren't prepared for it. We didn't know about it. We didn't know how to move forward.
Right.
So we worked with the authors of the annexation reform bills to try and make sure there was an adequate amount of advance notice so that ESDs could prepare. This is not an attempt to stop annexation. It's just an attempt to allow information and allow the ESDs to prepare for it.
Because this came out of what we were hearing, the feedback we were getting from ESDs about annexation was, look, we know in some cases we aren't trying to stop it. We just need to know so we can plan strategically ahead
Right.
when some of our territory or some of our tax base is going away. And so I think this was part of the measure, right?
Correct.
That
we worked with Representative Huberty's office and Senator Campbell's office to make sure that there was a notice. And the next slide talks about what's in that notice. Okay. And those kind of got to the important things that we needed to make sure about. That ESDs and other public entities, whether they're other water districts or other types of entities, would have this information. So the notice to the public entity has to describe the area that's proposed for annexation, much like the notice to the landowners and service providers. But it also has to include a description of any financial impact on the public entity that's resulting from the annexation. So the city has to come up with what's this financial impact. We're going to provide it to you so that you know. It needs to include any changes in revenues or maintenance and operation and costs that you might have as a result of our annexing. In addition, it's got to include any proposals that the city might have for how to abate or reduce that financial impact. It really is just bringing the information out about what's the ultimate impact to the public entities that are providing services like ESDs in the area that's proposed for annexation. Once again, it's an educational thing. If you're talking about Tier 2 annexation and voters who have to go decide how do they want services, this information will be more that will help them make a decision about how they're going to vote. If you're talking about a Tier 2 annexation that's by petition, that information gets out. People can decide, do I want to sign on this petition? If you're talking about Tier 1, where it's a petition process, this information comes out at the same time the notice of those public hearings go out, so that the folks out there being annexed can understand what's happening and make a decision about what they want to do. The law does say that a city cannot proceed with the annexation unless it provides this required notice to public entities. Now, there's one other provision in Senate Bill 6 that was an interesting addition, the enforcement, basically, of annexation laws. There is a specific language in the legislation that applies to any type of annexation, whether it's Tier 1, Tier 2, pre-SB6, SB6, says that you can only seek relief for annexation through a mandamus or declaratory or injunctive relief. So mandamus means I'm going to go sue you and force you to do something. Or I'm going to go sue you for declaratory or injunctive relief, which is declaratory meaning the court's going to say this is what the law is, you have to do it, or injunctive meaning this is what the law says, you have to stop. Those are the only ways you can get relief in annexation. A political subdivision's immunity from suit is waived. If you guys have attended ESD 101 or any of our other liability seminars, you know that political subdivisions in the state of Texas have governmental immunity as long as they're acting within the scope of their authority. And so for purposes of suits for annexation, a political subdivision's immunity or protection from suit is waived. In addition, the courts can award court costs and attorney's fees to a prevailing party. So if an individual wants to pursue a suit against a city for violating the annexation laws and they win, they can recover their costs and their attorney's fees involved in processing that case. That did not used to be the case. And so there really wasn't much opportunity for proceeding in the courts. That's a real quick run through on Senate Bill 6. Now there's a lot of detail, there's a lot of devils, but I know we've had a few questions.
We did have a couple come in, and I want to real quick, let's see if we can throw up the slide for how to get your questions in. If you also have questions about the new annexation law, SB 6, you can call us at 512-251-8101. Email safed@texas.net. You can text us. Text me right here at 512-567-0857. Normal text messaging rates may apply. Or you can even fax your questions to 512-251-8152. We got one question here. Can you go back, John, maybe to the slide where you discussed the difference between Tier 1 and Tier 2 counties? The one... Just run through those counties again. Tier 1 is the...
Oh, you want to see the list of counties?
Right.
So the Tier 2 counties, Tier 1's everybody except the Tier 2.
That last one, last one you just...
So the Tier 1 count, Tier 2 counties are any county with a population of more than 500,000. So Travis County, Tarrant County, Harris County, Fort Bend, El Paso, Denton, Dallas, Collin, and Bexar. The one that's not over 500,000 is Henderson, which got added in by virtue of the definition.
They have a fishery.
They have a freshwater fishery run by the Texas Parks and Wildlife Department. So Tier 2, as a county, establishes where annexation must adhere to the new SB 6 requirements. So if you're a city partially located in a Tier 2 county, then you're subject to SB 6. If you're a city located in a Tier 1 county, but you want to annex area in a Tier 2 county, you're subject to SB 6 and the new requirements.
So if you're a Tier 1 county, or a city in a Tier 1 county that only wants to annex...
I'll throw an example out here. Let's say in Central Texas, we have... Travis County, which is a Tier 2 county. We have Round Rock, which is located partially in Travis County, partially in Williamson County. So if it wants to annex territory, it's subject to the Tier 2 requirements.
Even if it's just annexing territory in Williamson County, which
Correct.
for those who aren't clear, does not have.
Because a municipality that's wholly or partly located in a Tier 2 county is a Tier 2 municipality.
Okay.
But I think, and I'm going to have to check my jurisdictional boundaries, let's talk about Liberty Hill. I don't believe Liberty Hill has city limits
Which is solely within Williamson County.
Travis County. It has city limits within Williamson County, which is a Tier 1 county. Mm-hmm. Liberty Hill, as long as it doesn't want to annex territory into Travis County, is a Tier 1 municipality. But if at any point it wants to annex into Travis County, it would be subject to the Tier 2 municipality rules. Okay. If you're from Liberty Hill and I've got my facts wrong, I apologize. I'm trying to use it as an example of where a city in a Tier 1 county annexes into a Tier 2 county. Then it becomes a Tier 2 municipality.
Okay, thank you for that very local question that we got, asking for clarifications on the counties. Let's get to some of the questions that we've already had submitted. Okay, so this is talking about commercial property annexations. And this is why I asked you about the less than 200 owners, because you could have a situation where they're trying to take, where a city is trying to take, say, one tract of land or one plant even.
Right.
We've seen that happen. Does 51% of property owners mean 51% of the total area targeted? Or is the 51% based on parcel ownership, regardless of parcel size? In other words, could they pick off one large desirable parcel by convincing two adjoining parcel owners to agree to annexation?
Well, remember that for annexation of areas with less than 200 in population, it's a two-step test. One is more than 50% of the registered voters in the area, right? So you got to have, if they're registered voters in the area, you got to have more than 50% of them. I don't think the law really addresses what happens if there's 0 voters in that area.
Right. So you got a corporation that can't vote.
Right.
That owns this plant that's in a.
There's not an answer to that particular question. There is, remember, a requirement that says a city can annex an area if 100% of the property owners, if they reach an agreement with 100% of the property owners. So if there are no voters, there is a mechanism for a city to annex by reaching agreement with 100%. But if there are voters, then you have to have a majority of the voters and a majority of the landowners. I believe the percent of landowners is percent of the land, not just the owners of the tracts. So if you had, 3 small tracts and 1 large tract owner, I think you're going to need the large tract owner, not just the small tract owners.
Okay.
Does that make sense?
Yes.
Sort of.
Sort of. It's complicated.
It's complicated. And remember, number one, the law hadn't come into effect yet. Number
Right.
2, it hadn't been tested in court yet. And so there's a lot of things in legislation that we just need to kind of work through.
Right. Well, we have a question from Henderson County, which is, as we learned, is a Tier 2 county thanks to your fishery.
Run by the Texas Parks and Wildlife
Run by
Department.
the Texas Parks and Wildlife Department.
I believe there are some
If
freshwater
another
fisheries.
county opens a or if TPWD takes over a freshwater fishery in another county, would that make that suddenly a...
That's possible, but I don't believe the state budget has enough money in it to allow that to happen.
Well,
I think Parks and Wildlife is stuck with the fishery in Henderson County.
Okay. So our question from Henderson County, Tier 2 county, how far out from existing city limits can a city annex at a time, and how often can they do it?
So, really specific question. Remember, we talked earlier about ETJ, and ETJ really limits where cities can annex. For the most part, there are some exceptions. If a city wants to annex, then generally the area must be contiguous to the city. So that means it's got to be right adjacent to the city limits. Now, there are some exceptions to that as well, but in general, it's got to be contiguous. As far as how far out they can annex, there's no limit. However, there is a limit on how much in volume the city can annex from year to year. Generally, it's 10% of the city's current area. However, cities get to carry forward unused percentages from year to year up to 30%. So the most a city can really annex of territory that it doesn't own, that's just a unilateral annexation, is really 30% of its existing area. Now, those rules are different depending on whether it's a home rule city or a general law city, so not knowing what city we're talking about,
question.
they're very fact specific.
Okay, there's a lot of steps, and consult it's all in the local government code, or is it spread out somewhere else?
Most of this is in the local government code, but there's a lot of case law and attorney general opinions that have interpreted the code to kind of help us figure out how to apply these rules as we go forward.
Gotcha. Okay, moving on. Enjoy your freshwater fishery, Henderson County. If our ESD is in a county that is currently less than 500,000 in population, but we anticipate it to exceed the population of 500,000 in a 2020 census, with the new annexation law, does the city still have to give the citizens or areas a 3-year notice to do any annexation prior to 2020? So if I'm understanding this correctly, you're saying you're going to become a Tier 2 county based on the 2020 census, which we had another question about a future census changing. So basically this question is, can counties change tiers? We know they can through election. If our producer can put up, can we get to that slide where they talk about changing Tier 2 county by election? So they can change to a Tier 2 county by election.
Correct.
Can a census change?
Well, so absent the legislature altering the population brackets, yes. If a county exceeds 500,000, it's going to become subject to the law. Now, the question becomes, what happens if a county's got a 3-year annexation plan in process, and all of a sudden it's now over the boundary? I think there's a reasonable argument to say now you've got to go through the Tier 2 process. You can no longer avail yourself of the annexation plan. Mm-hmm. I think there are some cities and counties with that kind of a circumstance that have been rapidly trying to move forward with their annexations in order to not have that question come up. I wouldn't be surprised, however, to see it tested in court. And remember, the enforcement law change allows folks to recover court costs and legal fees if they want to go pursue that. But I would think those cities, once the population of a county hits 500,000, are going to be subject to the new requirements, and anything in the past is just going to be out the window.
So, building on that, thank you, questioner, who sent in this question, which is a perfect tie-in with the last question. So, in Bexar County, so we know right now that the law is not in effect. SB 6 does not go into effect till Friday, December 1st.
Yes.
So essentially, no counties are Tier 2 counties right now, right?
Yeah, that's correct.
Okay. So in Bexar County, if San Antonio didn't complete their annexation by now, or Friday, let's say, where am I? This camera? By Friday, do they have to stop?
Well, so as soon as the law goes into effect, those requirements go into effect. And if a city hasn't completed its annexation, meaning it hasn't fully adopted the annexation ordinance, then it's going to be subject to the new requirements.
So that's kind of what we talked about with the census changing the city. If they haven't completed the annexation by now, like you said, there's a good argument.
Similar situations, and there are good arguments for that. There have been a number of cities, I think, in anticipation of those changes, going ahead and trying to push through annexations as rapidly as they can.
Right. Okay. Question, does a Tier 2 city have to provide the same level of service as the existing entity, or is it simply competition and education during the election process? So all of the old annexation process where we talk about service plans and all those kind of things, those are now limited to Tier 1s. So Tier 2 annexation is all about the election. And it's all about what the voters decide they want to do. If the voters vote to come in, the city's provided the information about what kind of services it's going to provide. They've gone through the public hearings. The voters say yes, it's done. The annexation plan and service plan process only applies in Tier 1. What about debt compensation?
So we can talk about compensation, but the compensation for the ESDs doesn't change based on whether you're Tier 1 or Tier 2. ESDs are still entitled to be compensated for their share of debt that is secured through property tax. Now, there are some components in that calculation, but the annexation process didn't change an ESD's right to be compensated for area that's annexed and removed from the ESD. You still have the ability to require a city to purchase apparatus or property that you can no longer use. You still have the right to have the city pay you a proportionate share of your debt.
Okay. Real quick, I want to throw up the slide that says how you may get in your questions. We still have time for a couple more. If you have questions for John about the new annexation requirements, you can call us at 512-251-8101. You can see the email is the general safety email, safed@texas.net. Texas is spelled out. Text me here in the studio, 512-567-0857. That seems to be most of your preferred method of getting your questions in. Normal rates may apply. And you can also fax us at 512-251-8152. So John, getting back to the law itself. Now, generally the legislature, and I like to say, we joke about the legislature, but generally the legislature doesn't just do stuff. They're generally trying to solve a problem. What was the problem that the legislature was trying to solve, either real or imagined? But what was the issue driving this? That's the underlying this key change.
So I think you have to look at the authors of the legislation. Representative Huberty, this is his second go-round at this legislation. He tried it again. He tried it originally in 2015. And his area that he represents had a huge annexation battle with Houston, or in the Harris County area. You had the same thing occurring with Bexar County in the last 2 years, which is why Representative Larson got on board, which is also what brought in Senator Campbell. And so you kind of had this convergence of annexation issues that those members decided were important. It aligns with the real property rights movement as well, which is the concept that people should be able to decide what restrictions are placed on their own property, and they should have a vote on that. And so whether it's limiting municipal zoning authority or the impact of municipal zoning authority, whether it's grandfathering uses, those kinds of things, annexation reform fell in line with that real property rights sentiment in Texas. And that's what drove annexation reform where it is. And that's what drove us to election. Now, I'll say that there have been a number of other issues at the legislature where election of the people has been promoted as the solution, whether that's property tax reform, whether it's eminent domain, all sorts of things are, get the people to vote and decide what they want to do on a more local basis. And that's the driver on it. I think there were some annexation challenges that had occurred in Bexar County and in Harris County, and those things snowballed enough to get this done.
So it's essentially the idea that some of these larger cities were annexing, and the residents that were being annexed into these larger cities felt like they didn't have a say in the process enough.
I think that started it. I think once that got started, you started to hear more about other cities, whether it was small or large, coming out and taking areas. There's enough of rural Texas left that doesn't want to have their property annexed without their blessing or consent that it became kind of a groundswell of support at the legislature for this proposition. And the urban representatives and senators didn't have enough support with their other members to stop this from happening. Texas Municipal League, I think, makes some good points. Annexation reform for them is potentially devastating to cities that are relying on annexation to increase their revenues so they can continue to function. It's going to change the model for cities in Texas to have to become self-sufficient and to have to convince people that it's benefit to be in our city limits, rather than, hey, we're going to come annex you, and so that we can get you to pay for the services you're already using. It's just a different format. We'll see how it plays out over time, but it'll be interesting. The state doesn't provide a lot of funding for ESDs, doesn't provide a lot of funding for cities. We're all, as political subdivisions, supposed to rely on our property tax.
How does this affect the suburbs? Let's say you have a small city in in a large county, but it's fairly rural and remote, they're under the same?
If you've got a small city that's in one of these tier 2 counties, they're going to have to comply with the same rules.
I'm thinking like of a Lago Vista out there where...
Sure. Remember, there are processes in place, and I'll equate it a little bit to the ETJ scenarios. There are processes in place where if people want to be annexed, it's real easy to do it. It's very easy to annex folks who want to be annexed as a community or as a group or landowners as a group. It only becomes more difficult if there's not consensus within that area. What you see outside the larger cities sometimes is landowners wanting to be in a small city's ETJ, which prevents annexation by the larger city. You may have that same thing occur. Folks in a small city's ETJ want to be in the small city so that they're protected from the bigger areas.
Okay.
Surely there's more questions.
Don't call me Shirley. You would think. I do want to highlight something at the end of your presentation. I'm not sure if you have it on here right now. But
which one?
The scenarios that you put in.
So
go ahead.
So one of the things that I don't think we really have time to go through, given the depth of the Senate Bill 6 changes, is these annexation scenarios, which I've got added in the presentation, and you'll be able to access after we've done. But I want people to understand how municipal annexation works with cities, irrespective of whether it's Tier 2 or Tier 1. So scenario 1 is you've got a city and an ESD that sit next to each other. They don't overlap each other. The city wants to annex area in the ESD. How does that work? Well, the city's got to go through all the process, whether it's Tier 1 or Tier 2. And if they intend to provide service in that ESD, they have to send the ESD a notice and says, hey, we're going to remove this territory. If they don't send that notice, that territory is not removed. Now, across the state, there are appraisal districts and voter registrars that remove that area automatically, but it just doesn't happen that way. The city has to make an affirmative decision to remove territory. Okay? It remains part of the ESD unless it gets removed by the city sending the notice. Everybody stays the same in terms of debt and holding their bonds. The law is in place for all of that. There is the way we calculate compensation for removal. I've got that in here. And on the ESD's request, the city has to pay for ESD equipment that it purchased at fair market value that it can no longer use. That's the result of a properly processed Scenario 1 annexation. The ESD loses the territory, the city gains it. In that circumstance, if the ESD had sales tax, ESD sales tax would go away in that area, city would gain it. Now, Scenario 2, this is where the ESD overlaps the city entirely. And the city wants to annex area in the ESD, but it's still in the ESD.
The city is in the ESD. This isn't a carved out city.
Correct. Which is my inartful pink highlighting of the city area.
Let's see what you were going for.
All right. So if the city inside the ESD wants to annex, they have to follow the same procedures. They could still remove the little territory in the green box from the ESD if they wanted to by sending the notice. But why would they do that if they're already getting all these services from the ESD and they're inside the ESD? So that's why they wouldn't send that notice. I go through this example because it's important why, if a city's trying to annex and remove territory, they have to send the notice. Because the way ESDs work in the state, ESDs overlap many cities in the state and provide emergency services in those cities. And cities may not want to remove territory from an ESD. So there's an option for the city and a process they have to go through in order to do that removal. In that scenario, now let's keep going. So I want to get to another one of my scenarios, and I know we're running short on time. Let's talk about sales tax, because sales tax gets to be complicated and creates friction between cities and ESDs. Now, we've solved some of this by allowing cities and ESDs to reach an agreement. But here's the scenario. There's a city that has that's not in the ESD. The ESD has 2%. The city, it is in the ESD, and the ESD has a 1% sales tax in the city. City has its 1%. If the city chooses to annex area, it doesn't get any of that 1% that it already had in the new area. It gets 0. That creates friction between the ESD and the city. And so there's a way to work an agreement between the entities to share that new sales tax. But in the baseline of the law, the city would get no sales tax in that annexation
The
scenario.
ESD's sales tax takes precedence.
It's a
over-
first-in-time situation. Unless
which they have talked about attacking.
Correct,
before.
correct. And so we've got a number of ESDs throughout the state that are sharing sales tax in these circumstances with cities. The advantage, I think, to the cities is the ESD has access to the sales tax that the city doesn't have access to. And so to be able to allow growth to occur and share that sales tax to provide essential government services makes sense. The comptroller is required as a result of some changes to the law that we made with TML a couple of sessions ago to share that sales tax with the to basically allocate that sales tax pursuant to an agreement that the ESD and the city might reach. If, however, an ESD has outstanding indebtedness that's secured by sales tax, then the city can't go in and take any of that sales tax away in an annexation scenario. So there are other ways to, like I said, to resolve the sales tax process. I don't want to spend too much time going through
Remember,
it.
all this is going to be on you will have access to this, probably should have access already to this PowerPoint. This is just for informational stuff about ESD and annexation. This is stuff you've covered before.
This is stuff I've covered before. I wanted to make sure it's out here again. Understand that it's really important to be communicating with other local governments in your area. Communicate early and often about what your plans are. The city's now got to provide you notice when they're intending to annex. That will help start the conversation. Remember that everybody has a different perspective, right? The city's focus is city residents. They're not worried about anybody that doesn't live in the city, and they don't have to be, really. The ESD's focus, however, is on everybody that's in the ESD, which may include the city, may include more than the city. And so your perspectives are different. And there's a lot of tools to be able to reach an agreement about sales tax and annexation and sharing those resources that I think benefits everybody. So.
Exactly. And so work with your city, and it's a long, complicated process that you will need to consult the law and possibly an attorney to understand how your fact-specific situation is going to be applied throughout the meat grinder that is the statutes and
This is a particularly complicated area of the law because over the years the legislature has put in a number of exceptions for particular cities in different circumstances that's allowed annexation for that city in that circumstance. Chapter 43 is really long. This comprehensive rewrite didn't make it any easier. And so I really want to caution you, if you've got an annexation situation going on, you need to be talking with somebody that's familiar with annexation law. They can help guide you through that process so that you can plan. You may not be able to stop an annexation, but you can plan for it. You may be able to help your folks understand what's happening with annexation, but it's important to understand all of the details.
it is a very tricky and complex topic.
Yes.
Thank you, John, for being with us tonight. We will be here, as always. Safety will be here with for questions. If you weren't able to get yours in tonight, we had one, I think, call in, but they called the studio phone, the text phone, and I can't answer you. So I hope that person is able to get their question in, and we know how to get in touch with John as well. I think I have your number somewhere. So. We can try to look into some of these questions if you have questions about the way SB 6 is changing things. Now to apply, well, I'm supposed to tell you how to apply for your 1 hour credit, but I'm going to plug the conference first before you are able to log off after you get your credit. So I want to talk about the Safety Annual Conference. John, are you going to be there?
Yes.
Okay. I wanted to make sure before
Yes.
I committed you to. I wanted to make sure you had your calendar open to be.
I did. I do have my calendar is no longer open.
Oh, okay. Because you are going to be at the Safety Annual Conference at Moody Gardens in Galveston.
I wouldn't miss it.
I would hope not. I don't know why anyone would miss it. It's going to be February 22nd through the 24th. There's going to be a lot of things going on there. We're very sorry if you do have to miss it. But we hope you'll join us. The hotel is open. The registration is open. Go to our webpage. safe-d.org to check that all out, and we hope to see you there in February.